Welcome to the MasseyDialogues. My name is Nathalie Derosier and I'm the principal of Massey College. Massey College is a place for ideas. It has for mission to nourish learning and serve the public good. Massey College is built on Indigenous land, the cherished land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. We are very grateful for the stewardship of the land and also for the ability that we have to continue to do our work here. MasseyDialogues is about having a good conversation about the interesting subject and bringing the voice of the intergenerational context. So we will have the specialist on the issues, but also we will hear from our junior fellows. So I am so happy today that we're confronting an issue that has polarized Canada often, which is the role of the reconciling Indigenous laws and settler law, Canadian law. As our Dayna Scott will describe in her paper, she calls it, what should happen when Indigenous law says no to extraction or to resource development, and settler law, Canadian law, says yes. She wants an alternative to this confrontation, to this clash. So it sounds so hopeful. So I can't wait to be able to talk to her. So I want to really welcome her here. She was a visiting scholar at Massey College last year. Her stay was interrupted by COVID. And so we're really happy that she agreed to do this dialogue. She will be joined by Myim, Bakan, Kline, the junior fellows, the law students, and the Honourable LaForme, who was on the Court of Appeal of Ontario for many years. So let me introduce my three speakers in a more fulsome way. So Professor Dayna Scott was appointed as York Research Chair in Environmental Law and Justice in the Green Economy in 2018. She's cross-appointed with York's Faculty of Environmental Studies. She's the co-director of Osgood's Environmental Justice and Sustainability Clinic, and she has been a law professor since 2016 after she completed some postdoc work at McGill and the Hauser Global Research Fellowship at NYU. She's been the primary investigator in many SSHRC-funded projects. She's a very productive scholar that I had the pleasure of following throughout her career. She is the editor of Our Chemical Selves, Gender Toxics and Environmental Health from UBC Press in 2015, a director of National Networks on Environment and Women's Health. She has been the recipient of a Fulbright Scholarship, of SSHRC Fellowship, the Law Commission of Canada Audacity of Imagination Prize that I was particularly happy that she got. And we're so delighted that she's here with us. Welcome, Dayna. It's wonderful to have you. So we're also going to have the Honourable LaForme, who is Anishinaabe of the Mississaugas of the Credit First Nation. He was born and mostly raised on this reserve where his family continued to be there, and he continued to remain active in First Nations government. He graduated from Osgood Hall in 1977, was called to the bar in 1979, and he went to article with Osler, Oskin Harcourt, where he joined the law firm as an associate, and shortly thereafter commenced a private practice in Indigenous law, focusing on constitutional and charter issues. And eventually, he has done so many things. I won't mention them all, but he was the co-chair of the Independent National Chiefs Task Force on Native Land Claims, the Chief Commissioner of the Indian Commission of Ontario, the chair of the Royal Commission on Aboriginal Land Claims. He's taught rights of Indigenous people at Osgood for many years. He was appointed the judge of the Superior Court, one of 3 Indigenous judges ever appointed to that level of trial. And in November 2004, he was appointed as a judge to the Ontario Court of Appeal. He is the first Indigenous judge ever appointed to an appellate court in Canada's history. And he retired just last year in 2018, but he's been busier since, doing all sorts of great work for on Indigenous law. And it's wonderful to have you the Honourable Harry LaForme, and we know that you're going to be joining Massey as a senior fellow, so I just want to say welcome. We're so delighted to have you here.
Thank you.
So let me introduce also Myim Bakan Kline from Vancouver, who's a junior fellow at Massey College. He's a JD candidate at the University of Toronto Faculty of Law. He's received a BA in political science with honors and distinction from University of Victoria. And his research is and interest are with Canadian Charter of Rights and Freedom, and particularly health law. He's served as a British Columbia legislative intern. He's crafted legislation with the Ministry of Health. He's been a research assistant at U of T Law. And also, we just find out he's a real avid jazz player because he's played in many drums in many groups, including the UVic Jazz Orchestra and also the Battle of the Bands winning group author with Sunburn. That sounds interesting. So anyway, welcome you all. It's wonderful to have you, and it's such an important subject that we're confronting today. So let me start with you, Dr. Scott. Tell me more about this project and how did you start it? How did you decide to undertake this work, and where it's at now?
Thank you. Thank you, Principal DeRosier, for inviting me, and I really appreciate the opportunity to be here to speak about this work, and also for the opportunity to join Massey College for the year, which is a really vibrant community, and I've benefited from that on my sabbatical. So this project, I began about 5 years ago, and I had for a long period of time been studying the regulation of toxics in Canada and air pollution. I did a little bit of work with Amdanang First Nation and the activists there who are fighting for environmental justice, and we're really working on air pollution issues. And I started to want to make connections between air pollution and toxics, as well as the refining of oil and pipelines and extraction more generally. And I started to really understand that sort of logic of extraction as being really woven into the fabric of environmental law. And at that point, the Ring of Fire was really coming into prominence as a kind of key challenge for Ontario, with this one side really strong push towards the extraction of those minerals for the economic benefit of all Ontarians. And, you know, on the other side, some really strong assertions of Indigenous jurisdiction that were coming from the communities in the region. And so to me, that looked like a really interesting place to sort of map out what was going to happen with respect to this encounter between Canadian law, or what I'm calling settler law, and the Indigenous laws that are inherent to the territories in question.
So it's quite difficult as a white woman to decide to undertake this project. So did you have to think a little bit about the ethics of it and how to go about your methodology?
Of course, every day. And, you know, this is one of the things lots of times graduate students ask me about. What's my place? Can I study this? Maybe it's not a topic for me. And I think it's something for each person to sort out for themselves. And there will be a whole spectrum of views about this, which I respect. But to me, it's about making those ethical decisions every single day in the research. About who am I accountable to? How do I fulfill my responsibilities to do my work with integrity, to be, you know, honest and accountable about it? And always trying to be useful. My colleague Deb McGregor at Osgood, an Anishinaabe scholar who has become a good friend, will say, you know, make yourself useful. And so really in my orientation to the communities, I don't want to be extractivist in my relation to them. So it's not just me and my research, and those are the priorities, but really trying to make genuine connection where it's on the principle of mutual aid and reciprocity, right? So I make myself useful by filing freedom of information requests, and digging up documents, and following case law, and offering advice, but also just like, sometimes just doing the work that needs to get done.
So where are you? Where's the research going now? Like, it's about finding the Indigenous law that's relevant to the area, and so how's the project developing? You were trying at one point, we talked about almost codifying the Indigenous law, or is that still going on?
Not really. I mean, when we did begin the project as a team project, we did have this idea that we would be able to understand the law of consent from an Anishinaabe perspective or an OG Cree perspective, and try and put that in conversation with Canadian law or settler law of consent. And really, it's evolved from there. I would say that the project is more now about thinking through, what are the sort of structural conditions under which these norms come into conversation, and really much more now a critique of the settler law in terms of the difficulty for really being able to understand consent from any other perspective than the one we're inside of.
So when we read your paper, you also talk about the role of treaty, and this has been mentioned several times throughout our dialogues about the importance of treaty law. Is there something that you want to share to the average Canadians who's watching about what does it mean when we talk about treaty law?
Mm-hmm. Well, I don't think I'm the right person to answer that question, but
I'll ask Harry after.
Yeah, I mean, I am trying to, and this really goes back to what you said before, like, do we understand ourselves all to be treaty people, all of us to be subject to the terms of the treaty? And if that's the case, then I think we all, settlers and Indigenous peoples, have obligations to learn about the treaty, what was promised, and how we can actually honor it today. Mm-hmm. And so for me, it's not only about understanding that, it's also trying to think a way forward. And as I was saying to you before, what is a way of relating for settler law and Indigenous law that doesn't always have to be conflict, right? It doesn't always have to be that they're in competition and one has to become dominant and exclusive, but that we might be able to kind of imagine a way of relating that's more reciprocal, it's based on mutual respect. It might include some areas of exclusive decision making, some cases over some matters, but it's more negotiated, it's more fluid, it's more about cooperation than conflict.
Well, let's bring in the Myim here. So you're listening to this. What does it tell you about your own career and your future work as a lawyer, and as a lawyer, presumably being in Canada? Does that anything in it that stimulates your imagination or your creativity?
Yeah, well, this work was incredibly interesting and incredibly stimulating, because as not a young lawyer, but maybe I'll be a young lawyer in a few years, and then there's many in my position, and we're all moving forward with a substantial degree of ignorance on these issues through elementary school and high school. There isn't really a robust educational method so that we can understand these core concepts that Professor Scott is talking about. And so when I was reading your work, one major distinction kind of came into mind, and that's between a constitutional pluralism that we kind of used to have in the very beginnings in the 17th century, and then that contrasting against kind of a much more contractual model with IBAs and economic benefit agreements and all these sorts of things. So so when I was reading, I was thinking, there's this regime of mutual respect and mutual recognition, and then it moved into a much more contractual understanding in the 20th century and 19th century, where all of the treaties were being interpreted within the confines of settler law. So these settler statutes would entirely define the circumstances in which these treaties were understood. So there could be extinguishment, certain aspects could be outlawed. And then we start moving away from this a bit, from not entirely, but through Calder and Section 35 and Delgamuukw and up to Tsilhqot'in. And so we have that jurisprudence. But then at the same time, and I was realizing this as I was reading some of the report, we still have this contractual regime. So a lot of the difficult issues have been stuffed into the private realm and essentially privatized to be dealt with the provincial governments hanging over, but also with mostly extraction corporations of various types defining the contracts. And all of it's pushed into this private regime when what really needs to be happening is a circumstance of mutual respect and mutual recognition, a more comparative or constitutional plural circumstance. So then the question is, how do we get there? We tried to get there in Charlottetown with the third order of government. That didn't really work. But then the Supreme Court's jurisprudence is moving a bit in that direction. So one thing that we can do, I suppose, is educate to show that there really are not two, but a plethora of constitutional orders at play. And that's a really powerful concept for me. And I think it would be really powerful for, my fellow students and people moving into the bar. So those were my initial observations.
Oh, thank you. Thank you. So let's bring in Justice LaForme here. So you're listening to both of these theories. Are you hopeful about the future of Indigenous law?
Well, I'm always hopeful. I'm less hopeful today than I was when I was starting out, because I didn't know what to be hopeful about when I went to law school. Mm-hmm. And I learned there was very little back then in 1974 when I headed off to law school. I mean, we didn't have these massive libraries full of treatises and writings on, and these thoughts and even original thinking on Indigenous law. Back then it was native rights, because the definitions of all of the Indigenous people were different. We were carved up into different groups, and we were status Indians and non-status Indians, and we were Inuit, or we were, back then it was even Eskimos. And now all of that's changed. Métis are now. One of the things that I did learn over my career, and it became even more apparent when I was a judge, and I understood the law from a jurisprudential perspective, and it dawned on me, I guess, a lot that this is a really, really monumental task. It is absolutely almost overwhelming, because there is a relationship here that just spun out of control in the 17th century, late 17th century, the 19th century, the first Indian Act and Confederation. What then transpired was this shift in that relationship that I don't know how it got there other than choice, but the relationship was that Indigenous people were less than equal in this country, and their rights were at the whim of the government of the day or the political parties, and indeed the people. I mean, then you have it constitutionalized in our Constitution Act that we are indeed less than equal people. We are the only ones in Canada that have a special section in the Constitution that allows the government to define who we are and how we live. That's Section 9124. Nobody else, none of you have that. I do. I still live under that authority. So that everything that gets decided, and that's what we've got to find a way to move away from, and I think Dayna touches on that, is that even if we were to talk the way the Supreme Court talks about some of these things, about jurisdiction of Indigenous people and their laws, etc., they talk about it coming through Section 35 of the Constitution. And that in itself is sort of jurisdiction that's being granted to Indigenous people. And that's a roadblock all the time. The second really, really powerful thing that goes on in Canada in relation to Indigenous issues and Indigenous laws is the white privilege that, and I'm not saying this out of any kind of criticism or being pejorative when I talk about white privilege. I mean, none of you think the same way about my rights as I do, or my grandfather did, or my father did. None of you can possibly know what that is like to think that way, like in your soul. You can't. You expect things a certain way every day. Dayna, the people up north don't feel that way at all, do they? I mean, I'm sure that they feel every facet of their life is regulated by some kind of bureaucracy or some kind of law. And they're right. It is. It is, except what they can do internally. And those are two obstacles that I'm not sure how we're ever going to overcome. Can I give you an example?
Yes, yes. Yeah.
An example is I mediate a land claim, an Indigenous person's land claim. Now, everybody knows, sitting around that table, that the reserve that they're talking about, that they were allocated in 1850, pursuant to a treaty, was about 1/10 of what it was supposed to be. And they know, for instance, that surrounding this area, that is likely to be turned over to First Nations people, right? Ultimately, when they settle this thing. But for them to be able to acknowledge that that is Indigenous land, they can't do at that table, even though they know someday it will, because the law all of a sudden comes into play, and that means that they have somehow accepted this legal notion that it's going to belong to the First Nations, and that will jeopardize these negotiations, because the First Nation then will have this admission that you recognize this as Indian land into court proceedings. They said there was a pipe carrier at the sessions of these negotiations, and he says, Ontario, you think that this land is a big real estate deal. We look at this land and the settlement as a new future for our people, a way for them to rescue themselves and to rescue our life and to turn around the tragedy that's within our community and make our community healthy again. That's how we look at the land claim settlement. Whereas you, Ontario, look at it as a real estate deal. And that is just abundantly clear. That's exactly what happens.
But is the fact that when Myim talks about, resisting this concept of privatization, this contract, the real estate deal, and moving to a slightly different place, a place maybe of openness and does that make you a little bit more hopeful about the fact that maybe the new generation may have more openness about at least looking at the legal concept with critical eyes?
I can tell you why. One of the things that Dayna said was that the question was, I think, was what's my place in this? And I know from my experiences on the Court of Appeal, especially with all the clerks that come in every year, more and more of those clerks come in, and their interest is in Indigenous law, in what we call probably the common law of Indigenous law. But I know that they think beyond that, and they write papers about beyond that. But they do ask that question. They do want to know what their place is in all of this, and that's really hopeful. Like when you listen to that, people are ready to listen. And when you listen to this government that we have today, when they first started, I mean, I would think every Indigenous person across Canada was hopeful about that without having to look into what that really means legally and constitutionally. But to say we want to break down and tear down the colonial regime, we want to replace it, we want to recognize the sovereignty of First Nations, nation-to-nation relations, and, you know, all of those kinds of words, I guess, and language is very hopeful. But then when you start seeing what it requires and what these negotiations really amount to, and there's this dependence on from the colonial governments of the law as it is. If you want to do this, we're going to have to find some kind of legal hook to put it on. And I think Dayna would agree, that's the wrong approach. We've got to do something beyond that and outside the box.
So this is the point of this research, isn't it? This is to sort of reframe or rethink some of the concepts from settler law to, you know, reflect different conceptions of legal orders. So I have a colleague who, you know, who comes from Cree territory, and she always says, I'm doing only private international law. That is, I only think about the fact that, you know, if I am in Ontario, I'm on Algonquin territory or on the territory of the Mississaugas. So what would that require? Does that require something happening within the Indigenous community as well? Or do you think it's mostly, there's still too much hurdle on the settler, on the Canadian side? Dayna.
Okay.
Well, I think there's a lot of work for settlers to do on the legal system in terms of really breaking down all of the colonial structures that are in place. So just to give you one example. So Myim mentions the Supreme Court of Canada jurisprudence and Justice LaForme as well, speaking about Section 35, how we typically deal with treaty rights. But if you were actually, you know, trying to rethink from the basis of a treaty relationship with two equal parties, surely you would wonder why one of those parties gets to establish the dispute resolution system and to use their law and appoint all of the judges. And, right, I mean, wouldn't we set up a system in which both parties got to appoint judges, and they would be people trained in both legal orders, and those orders would have to come into conversation somehow to come to, you know, resolutions? But those assumptions are so ingrained, right? And so, you know, part of what we're trying to do, of course, in the law school now is shake that up a little bit. And Myim looks like he's ready to go. Partway done law school already, having read all of those cases. But yeah, I mean, I think there's a lot of work for settlers to do in taking a hard look at the structures that we've created and the way we've decided that those institutions that are built solely on settler law should be able to sort of
define
grant rights to Indigenous people. You know, as Justice LaForme says, like, it's kind of delegated authority through Section 35. We grant you your jurisdiction. And that's just not the way people see it, not the communities that I work in.
So as a law student, is it encouraging to think that we can rethink the law school, or is it discouraging to think that all these cases that you're reading, you may have to reflect and rewrite eventually, if we want to get reconciliation, if we want to move toward reconciliation?
Yeah. Well,
who was you asking? Myim?
I was asking Myim, but I'm going to get to you.
Hear from Myim.
Yeah. So, you know, big question, how we move towards reconciliation. I'm not discouraged. I'm seeing programs like at UVic and with the JID and then some other programs across the country that are attempting to really embed these concepts around pluralism, around truly distinct constitutional orders in their students and in the bar. And this obviously isn't something that's been happening for that long. Not speaking ill of the bar now, but as we continue to teach those sorts of things, there will be more members of the bar who are more sensitive to them. And Justice LaForme was talking about, never being able to think the same, and that's so true. But what we can do is develop empathetic relationships, and we do that by learning about each other and by participating, at least right now, in these sorts of programs. So now, obviously, the UVic program is a single one happening at a smaller law school in Victoria, and I did my undergrad in Victoria, and it's a great place. But it's only one place, and it's a small place. So it's actually expanding those sorts of programs across the country and truly embedding that information in each of the programs. Because right now, maybe the Law Society mandates that I, in my first year studies, participate in X number of hours of, Indigenous law training. But how that occurs is up to the law school, and there's a lot of variance, and they're dealing with a lot of students at different levels of understanding. So there isn't some sort of defined program, and I can tell you that I don't come out of that training with a true sense of, wow, this is a distinct constitutional community, or there's a plethora of distinct constitutional communities. I come with that sense because I had the opportunity as a BC legislative intern to visit Nisga'a territory and to speak with the president and with the secretary and to try and understand, for only a short few hours that I got to talk to them, but to try and understand what that vision is like, what that vision that was fought, through Calder and Delgamuukw and all these cases, and what that really amounts to. And there are issues, but there are also some incredible advancements there. But that's, stacks of books in the treaty. We can't rewrite all the treaties. There's what, 5 or 6 in BC. Like, I don't see that happening in the short term. So in the short term, developing consistent education across the law schools, I think is really important, because it's just not there right now. And it was noted in the TRC report. So have to move there.
So yeah, let's hear you from Harry. What about you? Are you do you see that there's some work that is being done and that needs to be done?
Yes, I actually do. Not as big and as fast and as much as I'd hoped for. I mean, I guess the legal relevance of the settler, I thought would be less by the time I was 70 years old, right? And it's not. And I know people like to think Chilcotin is this great case and everything like that, and it talks about title and everything, but it's title in the same sense that a reserve is title. It's not. It's still not Indian land, really. It's occupation and use. That's all it is for Indigenous people. That's constitutionally entrenched in our laws. Mm-hmm. We have to think about what we really mean. I think Myim is correct that that whole notion about asking the right questions. What's my place is a really good place to start, but not just as a question, but really believing that in your mind. What is my place and how can I contribute to, and then try to figure out what it is you're contributing to. And that's difficult. So reconciliation I think, in my time, is not going to happen, because my view of reconciliation, I think, is a lot different than what a lot of other people's are, including our governments. Because whatever it is, they think it's got to fit into our constitutional framework right now and these jurisdictional differences and whatnot. Ours has got to fit in there. And that's the same way that they deal with the court. I was the first judge in Canada, an Indigenous person to be a judge in Canada on an appellate court in the history of the country. And I sat on that bench for 14 years. Not another person, Indigenous person, got appointed in any other part of the country or any other appellate court. I have been gone almost 2 years now, and there's still not another one. Now, you have to ask yourself, why is that? And the reason is because they think, I happen to be appointed at a very unique time when we had an attorney general and a justice minister who, Irwin Cotler, who thought a little bit differently than other people. And he knew exactly what he was doing when he appointed me, and he appointed me for that reason. And we don't have enough people thinking that way. Otherwise, you cannot tell me, and none of anybody participating in this can't tell me that there's not another Indigenous judge or lawyer across this country that isn't qualified to sit as an appellate court judge. And it's the same thing. We still respond to these issues and react to these issues the same way that we did during residential school times. And the theory behind the residential schools was, when you get to be like us, you can be Canadian. When we take the Indian out of you, then you can be part of us. And it's the same way in the appointments on the bench. It is, for example, you got to learn the way we do, and you've got to be, for example, again, bilingual. You've got to be functionally bilingual. Only then, when you become like us, can you share this space with us. And it's the same kind of thinking, and it's got to be gone. So when people say, what's my place, and really mean it because they want to know and have a sense of where they're going, that's different today. Those questions were never asked in my day. And I think that's progress, big progress. We're asking different questions today than we ever did 10 years ago even. And those questions are very important, and they're the right ones.
And so I think that's important that we ask these questions of ourselves and of Massey College, for example, and also I think we know when we ask the right questions, we may not get the right answers right away. So we have to be educate ourselves and so on. So we had a forum on treaties to ensure that there's, all of our students, not just the law students, understood which treaty, where do they live, where is Massey College, what does it mean to be here. But so if we had to design the next year's program for Massey College, Justice LaForme, what would you tell me to do so that I would know my place and help others know my place better?
Well, I think both Dayna and Myim have touched on it, and that is, like really understand your place. But one of the things that Dayna mentioned early on, which I think is very important, and it is not just what's my place, but where do I want this to go? Where ultimately, and we talked about the white privilege, and try to understand that, and that when you think about how to resolve a problem, for example, you simply say, how do I fix this problem? And you think about it in terms of your structures, your laws, your principles, your constitution, for example. How does it fit in there to do that? And that's how people bargain these things and negotiate land claim settlements. It's like, how does this fit into what I already know is the right way to do it? And it may not be the right way to do it, and understand that. But the most important thing, I think, is, and people do not understand this, is that we're all treaty people. Dayna, you mentioned this as well. We're treaty people. That means you have an obligation on the other side of those treaties as well. And it doesn't end just because you don't like it. It's still there, and you're still a party to that treaty. And your sense ought to be, how do I make this work? How do we get back to the relationship that we originally intended, that our Royal Proclamation of 1763 even reaffirmed? And we still don't know how to get there. And it's going to be difficult because, our jurisprudence and our Constitution are big, big obstacles to this. We don't know how to move away from stare decisis. We always tie our hands with some kind of principle as judges. That's just what we do.
So do you feel
I'm wondering.
Yeah, go ahead, Myim. Yeah.
Yeah. No, I'm just because I'm seeing two like general themes emerge. One, Dayna, you were talking about, the concept of the Supreme Court and having the settler state choose the judges and choose the forum and all these sorts of things. And then Justice LaForme, you're talking about developing the Indigenous bench, essentially. And these kind of relate to the two general manners of change. You can say one is a more grassroots integrated approach in a way. The other is a much more third order of government Charlottetown Accord sort of way. So I certainly don't know the answer of which is the best, and we may be past the point of these structural changes in Canadian constitutional politics. That hasn't worked twice before, and it may never work again. But should we try and pursue those sorts of structural methods, or do we need to move through much more grassroots, sort of developing the Indigenous bench, the bar, and do those sorts of things?
Are you asking me?
Yeah. Yes.
Well, I say both. I mean, obviously, one has to look. We have been the wards of this state for so long that we only know how to function as wards of the state, and we want to grow up. We want to become independent, and we want to live by ourselves, and that's going to take time because we don't know how to do that. We've got all these notions about our traditions and our traditional governments and how we used to govern our communities and whatnot, but we haven't done that in hundreds of years. And so we need to learn how to get back into that decision making and really mean it. I mean, my dad was chief for many years, and he always talked that way. He said, this is we're sovereign, we're independent and everything. And then he'd get involved in a land transaction or something like that. And the first question he would ask me is, do you think the Indian Act will let us do this? And we have to learn to grow out of that kind of thinking. So there is that. And then there's the big picture that Dayna has described very well. And that is, how do we move away into this position of where these dynamics, these different cultural issues and different jurisdictions can work together, like in the Ring of Fire, for example. We're saying no, and the province is saying yes, and as far as I know, the yes will win under the law that we are going to apply and care about today. That's going to win, and we've got to try to figure out a way where it doesn't necessarily amount to, but in order to do that, you see, there's always this legal hook that needs to be available. We'll do this, of course, and we'd love to do this, but like in the negotiations, the land claims negotiations, you want to call it Aboriginal title, or you want to call it treaty title, or whatever you want to call it. Well, how do we do that legally? That's it. They always ask that question. I can't do that, otherwise I
that precedent.
That's right. And I jeopardize our position, or I do this. And we've got to find a legal place to put this. And that's self-defeating. So we've got to do both. We've got to grow up, exercising our jurisdictions within the abilities that we have today, grow into that, and then expand it and later on into this big picture concept.
I was going to invite Dayna to speak because your work is about new imaginations in the legal world, and that's what's so exciting about it. How is it going? How do you kind of free yourself from the strictures that you've learned?
You know what, Natalie? It's by observing, really. One of the most exciting things, of course, is watching the land defenders express their jurisdiction, and not in the way that Justice LaForme is saying, not by using the language of Aboriginal title, but by just asserting and exercising jurisdiction on the land, and sort of expressing it in the language of obligations, right? So this is where you see one of the really main points of incommensurability with Canadian law and logics, right? Where land defenders say, I have an obligation to protect this territory. We're the stewards of this land, and Indigenous law requires me to protect this territory. And that obligation is higher than any sort of rules that it could apply to me that come from Canada or that come from Ontario, right? And when you hear people expressing that real conviction and putting it forward as an expression of jurisdiction, and I think we're forced out of those comfortable categories, and we have to kind of address that. So I recognize that, we don't have really good mechanisms for actually resolving those conflicts. So we all saw this with the Wet'suwet'en conflict this winter, just before the COVID pandemic. Obviously, all eyes were on that conflict over the Coastal GasLink pipeline and the assertion of jurisdiction by the hereditary leaders there. But it was also very inspiring to me, anyway, to see the solidarity actions across the country and the number of people that are really wanting to force a change in terms of how these decisions are made, how people can have some control over the decision making on their territory and really have the authority to decide. So, yeah.
I mean, COVID has put us a little bit on a pause on everything, but a theme that was constantly coming back on this dialogue, through these dialogue, is let's not go back and do the same old thing and that we got wrong. Let's use the crisis, the opportunity to rethink some of the ways in which we're going to move forward. And it could be that this is another area where there's opportunity to change. There will be some demands for Canadian development because there will be a big recession. And I have questions right now from the Canadian Business History Association. Could one of the issues be that Indigenous law is not codified and that at this stage could be viewed a little too abstract to be implemented, which would weaken its potential impact? Is that, Dayna, let's start with this. Do you think that's one of the issues that slows down, or it's more structural that we just don't want to see it?
I think it's definitely playing a role, and different communities are approaching this in different ways. There are lots of projects underway across the country where communities are giving a shot at what codifying their legal order would be. What is it like to put it down on paper? Can it be expressed in English? Is it the right thing to do? And there are those debates within communities, and there are and the University of Victoria actually has an interesting project for revitalizing Indigenous law through stories and teaching it through a case law method, and that involves a little bit of codification.
But it's interesting in a way to talk about codification because the common law is not codified. Yeah. So let's go to Justice LaForme here. What's your reaction to this question?
Well, the question would be, what are you going to do with that law, and who do you need it codified for? Mm-hmm. If it was for things like trespass on your reserve, or somehow you did something on the land that you occupy as an Indigenous group, okay, you charge somebody with trespassing, then what happens? Then you need a court, and then you need a prosecutor to prosecute that in an institution somehow. Then you need to discipline or collect fines for that. How does all that infrastructure work? And then if you codify it, where does it get recognized as being the law that we have to enforce and prosecute? It's within the internal community, but we already do that. Mm-hmm. We already do that. And the question will become when somebody like Dayna or Myim or you, Natalie, go into that community and commit some kind of offense that's contrary to the Indigenous law.
Yeah.
Then what happens? Do we put you in front of the chief and council, and do you get fined? And what if you don't pay that fine? Then do we have to go search you out? I mean, this is and even these questions, you see, get asked and answered in the context of what already exists in the settler structures of all of this. And that's where we're at. So I wish it were that simple, but unfortunately, I don't think it is.
But it's interesting because, here's another question from Ian Waddell. What does the judge mean by our Constitution is an obstacle? So Ian Waddell from BC is asking the question.
Well, our Constitution is an obstacle because of Section 9124 and the way the courts have, since the beginning, have interpreted it. And they've interpreted it as meaning the government of Canada gets to decide how we live from cradle to grave and what rights we have. I mean, the Constitution is there. That's what gives rise and gives jurisdiction to the Indian Act. I mean, the Minister of Indian Affairs can still, if he or she doesn't like the will that I provide upon my death, they can simply take over the administration of my estate under the Indian Act because I'm an Indian. And so, I mean, the constitutional obstruction is Section 9124.
Yeah. Well, and I think we've had before with Phil Fontaine on this dialogue the idea that, okay, we have to move beyond these crazy powers, and it's so that will be another job to do, to reinvent, to go beyond this sort of powers that are embedded in the Indian Act. You're smiling, so it's not easy to do.
No, I think I'm too old to take on that project.
Well, but we'll have to create the imagination. I think that's what we're talking about. Is the way in which
to do that. That's different.
So it's a big, tall order. There's lots of time to.
Absolutely.
That's it. So let's see. We're coming to the end of our hour. So why don't I ask you all to just kind of summarize your thoughts a little bit? What should the audience get from this dialogue? Let's start with you, Dayna.
Well, maybe, Natalie, I know you were going to ask me a question about COVID, so maybe I'll just go to that as the closing remarks. And that is, you were saying, what are the opportunities? Everyone is trying to figure out what the opportunity provided by the pandemic is, right? Mm-hmm. And in this case, what I see is massive infrastructure needs in a lot of Indigenous communities, and certainly the Treaty 9 communities.
Yeah.
Where drinking water is still a problem, where there's youth suicide epidemics, and there are massive community needs that are not being currently addressed. So if we're going to go into a big program of public spending, I really think we should be putting our minds to some kind of very creative rebuilding that restores Indigenous jurisdictions. So if we can think about that, if we can think about building in a way that supports Indigenous people's own visions for their homelands and really underscores and restores jurisdiction, to me that would be a good direction to come out of this.
Well, thank you. What about you, Myim? Anything that you're taking from this dialogue that you want to share?
Yeah. Well, I mean, a second component of that question, we were going to talk about how a possible recession or economic troubles could push, add additional pressure to an extractivist agenda in the Ring of Fire and also around the country. And we've seen that with Coastal GasLink and continual advancements there on account, when the land defenders had to move away due to the pandemic and all these sorts of things, and the company continuing to go in and develop that project almost as an opportunity. So that's something that needs, there needs to be vigilance there. Then in terms of the question that was asked by the Business History Association, I mean, everything was said by Professor Scott and Justice LaForme, but just generally, we're talking about issues of sovereignty and autonomy. So it really shouldn't matter what particular laws on trespassing or little things there and here. When you're talking about these broader issues, you're talking about something much bigger. But then just generally taking away from this, I'm optimistic. I'm excited to read Professor Scott's book. I'm really interested to hear about that sort of stuff. But also just thinking about these issues of plural constitutionalism and trying to embed that into Canadians and settlers' understanding of the relationship with Indigenous nations as much as possible, because I don't think that typically is something that we really have in that discussion with elementary school, high school, law school, undergrad. So, and it's a really powerful concept. It gripped me, and I think it can grip other people. So using that as a tool, because it's the most important part, and it's also often overlooked, I see. So that's what I'm taking away from this.
Well, I'm going to leave the last words to you, Justice LaForme.
Okay, I'm going to be really, I think I've expressed my views about the difficulties that we face, but on that subject, I will just say, I'm going to go back to what I've said a couple of times now. What's really encouraged me about even this discussion right here today is that the right questions by people are being asked. And it's like, the one thing is, what's my place? I think that is just an absolutely wonderful way to start this discussion. And I think it's so important. But then you go beyond that and say, what's my place? And really mean it. And then we go back to Myim's point, which is education is very important, because if you want to know what your place is, you've got to understand what it is we're talking about and where it is we want to get to in this whole thing. The second thing I would say is, really try to understand what reconciliation is all about. It's not about us, getting more judges on the court and doing all these other Indigenous judges, that is, and all these other wonderful things. Reconciliation in the big, broader picture is that whole understanding of can we get back to what we originally entitled or intended when we settled, or when people settled this country? What was meant, what were we going to do? Because I think if Canadians really understood that, they would want to keep that promise. They would want to go back there and do this the right way. And they just don't understand where we're at today. They don't appreciate that. And I think that education and that understanding of what that really means is very important. The last thing I'll say is on the COVID thing. For me, I'm going to really simplify it. And it's for another issue that I really, really have trouble with, and that's really dear to my heart. And that is, we have so much overrepresentation of Indigenous people in our prisons across this country. And it should be embarrassing to the entire country what those statistics are. We represent less than 4% of the population of Canada, all Indigenous groups, less than 4%. Indigenous people, men in prisons, are over 27% are Indigenous people. It's higher still for women, and it's higher even still for young offenders. So that's a really, really serious issue. What I hope COVID-19 and what we can learn from it is that our courts don't need to have everybody have to come into the courtroom and see them. I hope this technology takes it to such an extent that the people in the North, especially, that just go in and out of prison like crazy, those appearances will start and things will change that way, and it'll make access to justice that much easier for Indigenous people, and especially in the criminal law context. And let's just stop this overrepresentation. And that's one way I think that it can contribute.
For sure. And thank you for reminding us about this. This is an important issue that we want to discuss some more in terms of transforming the way we look at prisons, at sentencing, and also the responsibility that we have toward the statistics of our own criminal law system. So I want to thank you so much for being on Massey Dialogues. It was wonderful to have you, and it will be wonderful to welcome you finally in a physical sense, hopefully in the fall.
I'm looking forward to it.
So thank you very much. Thank you all. Thank you to Matt and Abra, the staff at Massey College, that allow us to have this great possibility of engaging in these discussions. Thank you to the audience for your good questions. And next week, we're going to have, on Tuesday, we're going to talk about global health with Dr. Joanne Yu, Peter Singer, and Jim Orbinski. And we're going to talk about freedom of expression on Thursday with John Russell Soul. So please come next week.